In January, we did my annual 31 Days to a More Effective Compliance program where we looked at one thing you could do each day. Well, we're back with the Compliance Tip of the Day. This is the podcast where we bring you daily insights and practical advice on navigating the ever-evolving landscape of compliance requirements. Whether you're a seasoned compliance professional or just starting your journey, my aim in this podcast is to provide you with a bite-sized, actionable tip to help you stay on top of your compliance game. In the chaotic world of 2025 and beyond, compliance will become even more important, and you staying on top of your game will help your company move forward. Today we look at what is CCO liability and, more importantly, how a CCO can avoid liability in regulated industries. There was recently a SEC enforcement action which really laid out exactly how a CCO can be liable in a regulated industries. In this enforcement action, I quote here directly from the administrative order, the CCO in question produced documents to the SEC, including pre-clearance trading forms relating to a particular portfolio manager. However, prior to providing these forms, the CCO modified the dates and or filled in missing information on many of the forms, which in many cases had been filled out after the trades were completed and after any oral trade authorization had been provided. By doing so, the CCO created the appearance the forms were completed correctly and signed on the date of the transactions. In certain instances where there had been no forms completed for a particular trade, the CCO created a form and affixed the trader's signature to it without the trader's knowledge or authorization before providing them to the SEC. So there are three ways that a CCO can become prosecuted by the SEC. Number one, affirmative participation in the fraud or other illegal scheme unrelated to the compliance function. This is where a CCO is directly involved in illegal activities or unethical activities that fall outside the compliance function, where a CCO allegedly obtained non-public information, for instance, from a relative's laptop and used it for personal gain. Two, efforts to obstruct or mislead the SEC staff. This includes actions taken by a CCO to hinder or deceive SEC investigators during an investigation. Obviously, the ballot case falls directly into this, and this is where a CCO is charged with altering documents or creating fictitious forms in response to an SEC examination. And three, wholesale failure to carry out a CCO's responsibilities. This happens in the cases where a CCO demonstrates a complete and utter derelict of their compliance duties. This can include neglecting to establish or maintain an effective compliance program or failing to promptly address known deficiencies. The SEC emphasizes it does not second-guess good faith judgments by a CCO based on reasonable inquiry and analysis if they're documented. However, when CCOs exhibit a fundamental breakdown in the compliance functions, they can face prosecution. It's important to note that a CCO prosecution for compliance failures, it frankly is very rare. The SEC seeks to avoid deterring qualified personnel from taking on the CC role and having this responsibility if they're going to prosecute. However, the CCO actions in one of these three categories can lead to prosecutions, and that's what has happened here in the ballot case. It's a rare situation where we have a CCO who engaged in such activities, and frankly, it's important for CCOs to understand that the SEC is not going to second guess them. So what are today's three key takeaways? Well, we're going to go over them again because it's the three areas that the SEC will prosecute CCOs. Number one, affirmative participation in the fraud. Two, lying, hiding, or altering documents to the SEC. And number three, wholesale failure and utter failure in your duties as a CCO. The bottom line is rarely are CCOs prosecuted by the SEC. One of the things that I'm happy to do for you, the compliance profession, is if you have a
question or a series of questions you would like some compliance tips on, I'm happy to take any requests that you might want, certainly anonymize them, and give you a quick tip. Either one quick tip or maybe a week's worth of quick tips. So if you have any tips you want about your compliance program, you can shoot me an email at tfox@tfoxlaw.com. This podcast was created and produced with the assistance of AI.